why in the last 2 months approximately has the child not went back to the plaintiff. Court will note the appearance of Ms. Bendelay on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody and return of child. Ms. Bendelay.
Thank you, Judge. As the court noted, we filed a motion. It was an ex parte motion for temporary custody and return of the minor child. My client filed a complaint with the court in October, I do believe. Essentially, the parties prior to this, they'd been separated for a year. The child at issue was 4 years old. They had worked very well with one another prior to September 11th, which was the premise for this particular motion that we had filed. Essentially, the parties had a, I guess, inconsistent parenting time schedule, but the child was with my client the majority of the time. As I'd indicated, they'd worked relatively well with one another, indicating when each of them would want the child. On or about September 11th, which was a Monday, my client met Mr. Mays in Bangor, Michigan, for the exchange of the minor child. Previously, both parties had been residents of Van Buren County. In around August, Mr. Mays did in fact move to Battle Creek, Michigan, Calhoun County, obviously. We understand that he moved in with a new significant other, whose address we have as his primary address at this point in time in the city of Battle Creek. So they did the exchange in Bangor, Michigan on September 11th. There, to my client, appeared no issues, no concerns. The transition went as smooth as it typically had in the past. Mr. Mays did in fact take the child at that point in time. On or about September 13th and 14th, which was, I believe, that Wednesday and Thursday, my client tried reaching out to Mr. Mays over the course of those 2 days to facilitate the return of the child. It was her understanding that the child was going to be returned that weekend. So Mr. Mays was basically having the child for the week. Mr. Mays did not, in fact, respond to her. Subsequently, he blocked her on social media, on phone communication, would not answer her calls, would not respond to texts. My client's grandmother also attempted to reach out to him. He subsequently blocked her. And that was the last correspondence that my client has had with Mr. Mays. She's had absolutely no contact with the minor child, even phone calls, since September 11th. My client, frankly, has no idea why Mr. Mays has precluded this contact for nearly 2 months at this point, Your Honor. I understand with our ex parte motion that the court's concern likely would have been the duration and time between the, I guess, separation of the minor child from my client and the motion, which we filed on the 23rd of October. My client filed her complaint initially. Frankly, I would indicate I don't think she was aware of the possibility of an ex parte motion for the return of the child. But and I'm sure the court has read our motion in its entirety, but my client took several steps in the time between September 11th and her filing in October of the complaint to secure the return of the minor child, or at least to determine her whereabouts. She called the police. I believe the Battle Creek Police Department or City Police was her initial correspondence. And essentially what she was informed was that the child wasn't supposed to have known whereabouts, so they couldn't constitute it as a kidnapping. All they knew was that she was supposed to be with the father. I would note that my client had not been provided the address or even the name of Mr. Mays's new girlfriend. She just knew that he was living in Battle Creek. She subsequently determined the address. She was informed by she was informed by a family member of Mr. Mays as to the name of Mr. Mays's new girlfriend. She'd had no contact with her whatsoever. She relayed that information to the police department. I understand a wellness check occurred, was requested. A wellness check was requested on or about the end of September. I understand that the Battle Creek police went to.
Okay, I don't think this is relevant to the hearing, so it's just extraneous.
Oh, okay, so essentially, Your Honor, we would just indicate that she made several steps to secure the return of the child. Mr. Mays has not made any sort of communication to her. He's not allowed her contact with the child when in fact she had the child the majority of the time before. We would ask at this point, Your Honor, that the court order the return of the minor child to my client. I understand that the child is currently enrolled into Concha schools. My client enrolled her there following the Mr. Mays's, I guess, refusal to return the child. Previously, the child had been enrolled for preschool at Bangor schools. Mr. Mays, I believe, subsequently tried to enroll the child in Battle Creek schools. We're not sure which school following her enrollment into Concha. We would just ask that the court order the return of the minor child, that the child attend preschool at Concha Public Schools. We had asked for no unsupervised contact with the minor child within our ex parte motion. I believe my client would be amenable to securing a every other weekend parenting time schedule. She does have concerns about the place that Mr. Mays is in fact living at this point. We would ask for no contact with Ms. Mays's girlfriend and the minor child if the court's so inclined. We believe, frankly, that the majority of these issues and no contact have been incurred and spurred by the new significant other. We understand that's going to have to be a hurdle that the parties will have to get over, but at this point in time for the interim, we'd ask for no contact, and we would ask for a support order reflecting the parenting time schedule in custody. Thank you, Judge.
Thank you. Mr. Mays, what's your response? You have to unmute, sir.
So there are a few things. One being that the minor child is in fact attending full-time preschool. She is in a very stable environment. As far as the no contact with the significant other, she is a foster parent. She also is a security guard for what she does for employment. Also, I have had her majority of the time. When the mother would visit, it would be sporadic. Sometimes it would go 3 weeks, closer to a month, before she would contact saying that she wanted her. There would be other times where she would say that she would want her for a couple of nights and keep her for 2 weeks, give or take. I'd have to say at least within the last 2 months or so, I've noticed through other court hearings that she has had at least 4 different addresses. So I'm just not really sure on what's going on her behalf. But
Okay, tell me what happened prior to the November 11th date. Sound like that the child was going back and forth. What was was there a normal schedule prior to that time?
No, there was not.
Okay, why, from what you said even, is that the child did go back and forth. So why in the last 2 months approximately has the child not went back to the plaintiff?
So there was a time where she had let her oldest come and stay.
I don't care about the oldest. She's not a part of this action.
So the main thing is the whole school. So she had mentioned it to me that the minor child wanted to go to school, and I enrolled her here, and it took a while. And then she notified me that, or the mother notified me that she had enrolled her in Van Buren, and it just took off from there.
Okay, that didn't answer my question. I'm saying, why in the last 2 months has a child not seen the plaintiff?
Because I have reason to believe that the mother won't return her.
Is that because you didn't return her?
I'm honestly unsure.
Okay. Anything else, sir?
She also has doctor's appointments and dentists scheduled that she is or will be attending, and she wasn't really getting that. She wasn't getting the medical attention that she needs.
Okay.
Judge, may I briefly respond?
Yes, go ahead.
Thank you. We would first note as to the Mr. Mays's comments as to doctor's visits. The child had a doctor's appointment in August of this year. My client communicated to Mr. Mays via text message that the child had the doctor's appointment when she was with Mr. Mays. She missed that appointment. My client has enrolled with the children, I guess enrolled, basically issued her at Concha's Oaklawn Medical Group. She has a doctor's appointment scheduled on November 22nd. It's our understanding that she is behind on shots at this point. She was supposed to get those shots in August. Frankly, my client contests that she was not getting the child, adequate medical attention. As to schooling, my client had her enrolled at a preschool in Van Buren County. Mr. Mays, to our understanding, did not in fact enroll the child in Battle Creek schools until on or about October 5th, when my client received a call regarding information for enrollment of the child. Mr. Mays had instead represented to my client that he wanted to homeschool the child full-time, to which she did not agree. And at this point in time, we just maintain that Mr. Mays has not presented any legitimate reason as to why the child should be separated from the mother for 2 months, let alone without any contact with the mother for 2 months. We disagree and contest the fact that he's saying that he had the child the majority of the time. My client maintains that she had the child majority of the time. If anything, Your Honor, I think they may have been closer to a joint legal, joint physical custodial arrangement. But again, my client maintains that she did in fact have her the majority of the time. And we would ask for a custody and support and parenting time order reflecting that.
Okay. Well, what the court's going to do in this matter is there is conflicting, obviously, testimony in this case. And as just recently stated, as prior to the November 11th date, the parties did appear to be doing a joint legal, joint physical situation, which was somewhat, I guess you'd say, less than regular, but that they were doing it in some event. What the court's going to do is on a temporary basis, the court's going to grant the parties joint legal and joint physical custody. I'm going to do that in alternating weeks. So the court will order that the child be turned over to the plaintiff this Friday at 6:00 p.m., November 10th, 2023, and she'll have the child for a week. And then the child will go back to the defendant. Court will also order that the parties would alternate legal holidays, and court would order support consistent with the income of the parties, the child support formula, and the joint physical custody scenario. Yes.
I request that she stays in her current school if able.
Well, she's in preschool, isn't she?
Yes.
Okay, the court's not going to address the preschool issue at this time. Parties, if the parties can, the child can have the child in a preschool when they're in their respective care. I'm not going to order that now, as the preschool is not mandatory. So that will be the order of the court. Ms. Bendelay, I'll ask that you would prepare an order and submit under 7-day notice of entry. That will conclude this matter at 9:28 a.m. You're free to go. Have a good day.